Thanks a million. Well done to anybody who hasn't already got me muted, in fairness, at 3 o'clock. I probably should have entitled this CPD things that have been across my desk. I just figured that we're all probably a bit sick of hearing all about the personal injuries guidelines, and we've all probably got a lot of talks all about them, etc., etc. And there's nothing really new to say, despite the fact that I have thrown in a little bit about them at the end. So some of the stuff that I'm talking about isn't necessarily new, but it is just stuff that keeps coming up, hence things that are across my desk. And so kind of worth a bit of a discussion. And a few of the things are things that are kind of emerging in terms of litigation, or that there are kind of things coming up that maybe have recent decisions in that maybe have been decided not so recently but are still relevant. So I'm kind of moved into two categories: pre-litigation issues and then kind of issues that happen during litigation and on appeal. So you'll see there PIAB authorization and then settlement negotiations, estoppel and the statute, and then sort of general tactics like rule changes and interrogatories, pleadings, general chat about the Court of Appeal. I have slightly thrown in the guidelines, I won't be too long on those, and nervous shock. And if I can manage to cover all of that in about 45 minutes, we'll be doing very well. So just in relation to a PIAB authorization, I mean, again, it's not necessarily a new issue, except it has come up recently in relation to GDPR claims, which is probably what I want to talk about. So a bit of the background that everybody probably knows is that previously there was debate over whether assault claims and medical negligence claims, and particularly product liability cases arising out of medical negligence claims, generally kind of the Dupuy hips and those sort of cases, whether or not they required an authorization from PIAB. We had a few cases where the sort of original one was Gunning in the maternity hospital, where Judge O'Neill said, look, you have to look at the entire case and the way it's pleaded. If it's pleaded like a medical negligence case, then it comes within the exceptions under 3D of the 2003 Personal Injuries Assessment Board Act, and therefore it doesn't have to be authorised. But you can't take kind of a piecemeal bit and bob out of each bit of the pleadings. You have to take a holistic approach and look at the whole thing in its entirety. Then we had other cases which followed that said, no, if you're going after a manufacturer of a product, then that isn't a medical negligence case. And so therefore that aspect of the case does have to be authorised, but you don't have to authorise if you're suing the surgeon or the hospital, for example. So then we had a strange few years where you had to get an authorization as against one defendant and no authorization as against another defendant, which meant that your time period while the claim was in PIAB was stopped against one defendant and not stopped against the other, and the whole thing was a bit mad. Then we came down to the Court of Appeal case in Creedon, or Murphy and Dupuy, and eventually we went back to the Judge O'Neill school of thinking, where we just look at the case as a whole. We decide whether the case as a whole needs an authorization. What's the entirety of the case about? Is it a medical negligence case? Is it not? And essentially, of course, a hip replacement or a knee replacement, something like that, only arises in the context of medical proceedings. Therefore, it comes within the exception. So that's kind of the background of the previous debate. The same in relation to assault cases. Are they personal injury cases or are they not? And then we came to Clark and O'Gorman, which essentially, kind of in a nutshell, said two things. Number one is that the issue of applying to PIAB is not a jurisdictional bar. So it's a matter that has to be pleaded in the defence. And essentially, it secondly said that a personal injury action, an action that requires an authorization is a cause of action other than that in which personal injury is claimed. So we can kind of take from that the rule of thumb is if you're seeking damages for personal injury, an authorization is required. Then there comes the debate about, well, what is the statute of limitations then? Is it 6 years for assault? Is it 2 years for personal injury? And that's relevant as well when we're coming into the sort of GDPR data breach claims as well, as to what the statute will be on those. So Dillon and Irish Life is a very interesting case. It was recently just heard by the Supreme Court. So it started life in the Circuit Court. The plaintiff had claimed a non-material data breach, but it also included in their claim that they had suffered distress, upset, anxiety, inconvenience, loss of damage. And the defendant's case was that constituted a civil action for damages as prescribed by the 2003 PIAB Act, and therefore it required an authorization. The problem being that the Civil Liability Act 1961 has a very broad description of what a personal injuries action is, and that's any disease or impairment of a person's physical or mental condition. So despite the fact that distress, upset, anxiety, isn't actually a recognised psychiatric or psychological illness for which you might recover damages, that distress, upset, anxiety, the point being that that was covered by the very broad description of a personal injuries action in the Civil Liability Act. So you wouldn't think, and I think the way that the case was drafted, it was drafted as a data breach. That was kind of thrown in as, in addition, the plaintiff suffered distress, upset, etc. You wouldn't necessarily have thought that that was a personal injury case, and yet the Circuit Court dismissed the proceedings. There was an appeal to the High Court. The High Court said it was difficult to treat a claim for distress and upset and anxiety substantially different to that of a stress, which did amount to a formal personal injury claim. And there was a previous claim in the Supreme Court, Buds, I think it was Murray and Buds, that said the same in relation to sort of stress, upset and anxiety in a professional negligence action, that did amount to a personal injuries action, even though damages for stress and anxiety wouldn't be recoverable as a personal injuries claim, which is all a bit strange, but in any event. So again, the High Court held that it did amount to a civil action and therefore did require authorisation. So that has now been heard. It was appealed in a point of law to the Supreme Court, which in and of itself is important. The Supreme Court decided to take the case because it did have points of law of public importance and that it needed clarity on the issue. The Supreme Court heard the case at the end of January and we're waiting on a decision from the Supreme Court. But there's a couple of things that'll be really important depending on what the Supreme Court says. So to my mind, every single loss of consortium case that I've ever pleaded or I've ever been pleaded a defence to includes something to the effect of distress, upset and anxiety, sometimes a little bit further. Sometimes there's a medical report in relation to sort of a psychiatric injury. I've pleaded several times the fact of an authorisation if the pleadings go forward, go further than just distress, upset and anxiety. It's never really gone any further. Usually they're thrown in with another action. But if the Supreme Court find that simple claim in Dillon that the distress, upset and anxiety is a personal injuries action which does have to be authorised, then to my mind, every loss of consortium case would have to be authorised. And equally, a defamation case, quite often you'd have, well, I was very upset by the defamation and I suffered distress, upset and anxiety. Do those require an authorisation then, depending on what the Supreme Court say? I'd be very surprised if the Supreme Court said that it was a personal injuries case, because then almost every case in which you simply say that you suffer distress, upset and anxiety, which would follow that you'd have in a summons in relation to defamation or a breach of GDPR or loss of consortium, then those would all be personal injury cases. But on top of that, there would be an argument that all of those have a statute of limitations period of 2 years. So there are huge ramifications for an awful lot of cases if that case comes out of the Supreme Court and does say that that pleading in and of itself amounts to a civil action for the purposes of the Act. Now, every case is fact specific, and I know that certain GDPR breach claims are also personal injury claims that do seek damages for, say, a psychiatric injury. So ones that are pleaded as a non-material data breach, simply thrown in with distress, upset and anxiety are one thing. Cases that are pleaded with psychological injury or go a bit further are another. So I think it's really important to look at the case as a whole, to look at the case the way the case is pleaded, and then kind of make a decision as to whether or not, you think that the case requires an authorization. But the important point about all of that is, if it does require an authorization, you may be looking at a different statute period than you possibly thought, and the case may be statute barred, which obviously you have to plead, and also you have to plead the issue in relation to a lack of unauthorization. If you don't plead those, you mightn't necessarily get an amendment down the line, because the court can be very strict in relation to those particular amendments. So that's just worth bearing in mind when you're looking at the case. Look at the entirety of it. Even if it's pleaded in a certain way, even if it's a plenary summons, it's not a personal injury summons, that doesn't mean that it's not, in essence, a personal injury claim. And I've just said there at the end that the pre-litigation correspondence in relation to that might be crucial. So that brings me on to my next point. But what I mean by that is, frequently you'll get solicitors, particularly in medical negligence cases, plaintiff solicitors who write and say, we are of the view that this case comes within the medical negligence exception of the 2003 Act. Please confirm that you agree, or something like that. Or please confirm that you don't require us to apply to the Injuries Board. And then later on, if there's no response, or the response to that in correspondence is, yes, we are also of the view, or whatever, then later on they'll rely on the doctrine of estoppel to say, well, you didn't take us up on the issue. You didn't say we required an authorization, therefore you can't suddenly turn around now and put in your defence that we did. So be careful of that kind of pre-litigation correspondence. The point was raised in the Court of Appeal, I think it was, in Creedon and Dupuy. And in fairness, the court was like, no, there was no response to that initiating suggestion of whether or not an authorization is required. You can't simply sit back in your laurels and take silence as, acquiescence and say, oh, well, the defendant can't rely on it now. But at the same time, you'd have to be careful as to what you did put in your correspondence. And there's no guarantee that a later judge mightn't say, well, why didn't you write back and say, no, we didn't think it was. Probably the safest response is a without prejudice response, obviously. But also to say, we're not in receipt of your draft proceedings. Upon receipt of your draft proceedings, we'll make a decision in relation to that. We're not taking a stance on it currently, or we're not giving you any comfort. That kind of a correspondence, I think. Because as we'll see, just in relation to this next topic of pre-litigation correspondence and engagement, sometimes the court can put it back on defendants as to what defendants did or didn't do, and not necessarily put the pressure on the plaintiff, particularly in terms of the statute of limitations. And there's one particular case I want to talk about that seems very unfair. Again, it's not a new case. So the other kind of pre-litigation engagement is obviously in relation to the identity of the defendant. Again, if there's correspondence seeking the identity of the defendant, or saying, please confirm if this is the correct trading, this is the correct entity, etc., etc. Clearly, plaintiff solicitors under obligations to ensure under the CRO and all of that they have the correct defendant. But at the same time, if there's correspondence preceding that in which either the wrong name was named and nobody corrected them, or it was clear that they were going to name the wrong entity in a PIAB application form, again, you might be precluded from them turning around, once a barrister or something gets the papers on the desk to say, oh, well, you're statute barred because you didn't name the right defendant. It'll depend what's in the correspondence. But again, just as to what you can rely on later, estoppel might be raised. The main thing that keeps coming up, though, in relation to the issue of equitable estoppel is kind of pre-litigation settlement discussions. And that's kind of one thing that I want to talk about in detail. So obviously equitable estoppel is where the conduct of the communication on behalf of the defendant could be said to have lulled the plaintiff or their solicitor into a sense of security in relation to an issue which then later arises, and basically prevents you from turning around and saying, oh, gotcha, you're statute barred in particular is the one I want to talk about. So again, same with the requirement for a PIAB authorization. If there's correspondence about that, careful in relation to that engagement. You need to look at what the engagement is in relation to an identity of the person who's being sued or the defendant. The statute of limitations is the one that keeps coming up. And in fact, there was a case due to be heard this week about it, which I thought could be interesting if there was a decision out, but in any event, it has of course settled, so I don't have any update there. But there's three main cases: Supreme Court of Murphy and Grealish, 2009. There's one from Judge Barton in 2017, McFadden and Newhold, and then two, if I'm pronouncing that right, I'm probably not, and Campbell Catering is a decision of Mr. Justice Heslin. Two is the most recent one, and it seems very unfair to the defendant to my mind, but it was a circuit court appeal, so it never went any further. So everybody's kind of stuck with the decision. But basically, the entire history of the correspondence is going to be at issue if estoppel is going to be raised in relation to defeat a defence of the statute of limitations. So there's a couple of things that were discussed in that case. So liability wasn't at issue, and liability had been openly admitted. And then there was kind of a general discussion to try and to settle the case, as there often is. There was a couple of phone calls, there was a couple of emails. The statute was up on the 3rd of December 15, and there was phone calls in November 15. Now, interestingly, in that case, I'm conscious there could be somebody online who was in it, who probably knows far more than me, but interestingly, the plaintiff solicitor hadn't returned the phone calls from the claims handler. And hadn't written back either. So it's kind of an unrequited or unanswered calls and correspondence. And then the statute comes up in December, I think it was the 3rd of December, and the PIAB Form A was lodged 5 days late. Now, to my mind, probably to everybody's mind, you're thinking somebody forgot. And then lodged it 5 days late. The defence to the statute of limitations issue, which is what the motion, there was a preliminary motion issued. And the defence to that was, well, you can't raise it now because you were chasing me in relation to settlement. You'd admitted liability openly. You never gave me the impression that the statute was an issue, so I wasn't worried about the statute. And the reason that I didn't come back to you was because there was an error in my medical report, and I wanted to get that fixed before I came back to you. Now, I think the error in the medical report was that it related to the wrong leg, the left instead of the right, or the other way around. And in fact, the solicitor ended up lodging the incorrect medical report with the Form A, but 5 days late. So again, that would, you would think, create the impression that there was always an intention to lodge the Form A within time, but that maybe just something went awry, whereas the sworn affidavit on behalf of the plaintiff solicitor was that they weren't worried at all about the statute because of the conduct of the defendant. The kind of key takeaway points in relation to that are that, okay, obviously all correspondence is going to be gone through, but secondly, liability is really a key issue. So if you look back through the case law, which I'll just summarise and then taking you back through all the case law, there's kind of two schools of thought. I mean, liability seems to be a really key thing, but it doesn't necessarily follow that just because liability is admitted that therefore estoppel is there and you can just sit back and not do anything in relation to the proceedings because liability is admitted. It's obviously a big difference between liability not being an issue and an active kind of stance of trying to settle the case before proceedings issue. So Murphy and Grealish have just done a quote there. And again, it doesn't even have to be liability, it doesn't have to be openly admitted, it can be kind of by conduct. So looking for a medical report, say, or saying, are you interested in settlement discussions, etc. Sometimes that can be enough to imply that the conduct is suggestive of the fact that liability won't be an issue. The timeline is important, as I've said. In the Sue and Campbell catering case, there was kind of approaches to settle right up until about a week before the statute. Each case will obviously turn on its own facts at the same time. So Heslin, Mr. Justice Heslin kind of sets out these 4 things. I've changed the layout there, but these are basically the 4 things that he says. Number 1, liability isn't an issue. Number 2, the defendant was anxious to settle the case. 3, it was seeking a medical report. And 4, it was doing so without reference to any time limits or any other conditions. 4 seems very unfair because the plaintiff knows, or should know, being the point, that they have to lodge the Form A within time, unless there was some express comfort by the defendant to say, you know, please note, we don't need you to issue proceedings, or please note, we don't need you to lodge a Form A. But actually, the judge obviously took an alternative view and sort of almost put it back on the defendant that, well, you didn't say that there was any time limits or that there was, you know, this offer will expire by, or if you don't get back to me before the expiry of the statute, then all bets are off, etc. So these are the kind of elements that he said: an unambiguous statement liability wasn't an issue, an explicit desire to settle the case, a request for a medical report, and no reference to time limits or other conditions. Again, to my mind, those 4 things are very easily satisfied in terms of any pre-litigation engagement that might happen with plaintiff or plaintiff solicitor. You know, if you are anxious to settle the case, of course you want to settle the case before proceedings issue and save costs in that regard. You may well, and I've seen cases where the plaintiff, you know, there might be a without prejudice admission of liability and the plaintiff solicitor says, I'm not talking until you've an open admission of liability, possibly with this kind of case in mind. Again, looking for a medical report, explicit desire to settle the claim, it can be very easy to fulfill these criteria. And this is kind of the most recent case that there is. I think there will be a case, possibly soon enough, where this will change, because I don't think, you know, it seems fair that a plaintiff solicitor can just sit back and say, oh, well, they wanted to settle the case, so I wasn't going to get on with it. But it's easily avoided at the same time if in correspondence you simply say at the outset, you know, please note, we are reserving our position in relation to the statute of limitations, or we still require you to comply with the statute of limitations. Or else if you're cutting off settlement discussions or like that, somebody isn't getting back to you, you simply say, we're now going to, you know, let the matter proceed to PIAB. And settlement discussions are closed or something like that. But I think this case puts the onus nearly back on the defendant to say something in relation to the statute or a time limit or some sort of condition, as Heslin puts it, so that the plaintiff can't then turn around and just rely on estoppel to defeat the statute of limitations. In relation to issues which arise during litigation and on appeal, this just again a couple of mismatched things, but one tactic that nobody's kind of really using yet, in fairness, it's only kind of come out relatively recently, is that on the 31st of July 2024, there was a rule change in relation to interrogatories. So, like we all know, particulars are great, but most of the time we get a response that says this is not a matter for particulars, quotes Armstrong and Moffat. We don't really get an answer. We don't really get very far. Sometimes you get a few bits that you need, but you still have to go down the road of discovery, etc., etc. So nobody really used to bother with interrogatories, except maybe in a medical negligence case or commercial case, because you had to get the leave of the court to issue and serve them. And it was just kind of an expensive pain, really. Whereas now you can serve one set, which are less than 20 questions, without the leave of the court. And it has to be obviously a yes or no question. You have to set out a brief statement as to why the answer to the question is necessary, but they can be really useful. Number one, because the other side has to respond. Their response can be that they're not responding, but they have to give a sort of detailed explanation as to why they're not responding, if that's the case. They have to do that by way of a filed and delivered affidavit. They have to suggest or to set out their grounds of the objections and any alternative ways to address the issue. And then if you're not satisfied with that response, a motion can issue. So it's kind of very difficult for the other side to get out of answering the questions. And if it's something like, you were going to get discovery of the plaintiff's pre-existing medical records to prove that they were still symptomatic, a year before the accident in relation to some prior issue, again, you can say, did the plaintiff still have neck pain at the time of the accident? The answer is obviously either yes or no. Again, if the answer is no and that turns out to be false, then great. Or, if there's some issue and dispute in relation to training, does the plaintiff accept that he received training, manual handling training on the whatever date, depending how pernickety you are to say, does the plaintiff accept that training included whatever it was that you're trying to, and then that saves you in terms of evidence that you then have to prove, because there's your answer on the interrogatories. If you narrow down the court time, costs, etc., might require less witnesses on your behalf and might substantially cut down the need for discovery. So, and equally, if a plaintiff comes back and starts getting very convoluted reason as to why they're not answering the question, then that might tell you that you've asked a particularly pertinent question that the plaintiff absolutely doesn't want to answer, and you've put them under significant pressure. So I think it's one that'll be used a bit more often, but it hasn't really. I think because it's been a very recent rule change, nobody has sort of made proper use of it yet. Certainly motions and things like that aren't really coming before the courts as of yet, but I think it's a really good tool that can be used quite early on, and can really put people to the pin of their collar in relation to what they have to answer. Obviously, the corollary to that is they can ask us also. So everybody is going to have to answer the question. But certainly if you have a case that's going to take 5 days, if there's interrogatories on both sides, you may well end up narrowing, everything down to 1 or 2 days and possibly narrowing the issue of discovery. Just very briefly in relation to pleadings. So, we've had a few years where plaintiffs are being, very heavily scrutinised in respect to their pleadings. Section 26, we know there's a lot of case law now in Section 26. It's being used to great effect. Plaintiffs, again, replies to particulars, interrogatories, whatever it may be, are getting caught out in relation to their pleadings if they don't disclose a previous accident. If they say an accident happened elsewhere, something in replies to particulars, plaintiffs can be caught quite easily in relation to pleadings. And then how far you go with that just depends on the case, obviously. But there's been a lot of scrutiny on plaintiffs. There's been some scrutiny on defendants, but not necessarily to the same extent. So again, for years, and we still have them in the circuit court, a bit less in the High Court. But I mean, if the personal injury summons that just says, breach of the Safety, Health and Welfare at Work Act and nothing else. You've particulars of negligence that are just aimed at all 5 defendants, nothing separated in relation to which defendant is which. A general kind of trawl of you were negligent, but you've no idea why, and then you have to go through all of this raising particulars, etc., etc. That's kind of gone since Morgan and the ESB in 2021. Then before that, Green and Harty. So I mean, in the circuit court, I mean, anything, as we know, kind of goes, and you just get away with it. How long that will be for, I don't know. But in the High Court, it's definitely pleadings can't be sort of broad sweeping and boilerplate, but that is definitely goes for defendants as well. And we're starting to see plaintiff solicitors really lean on that and Civil Liability Act to write back in relation to defences and say, sorry, you're not specific enough. You need to be much more specific in your defence. What is your defence? You can't just put in a traverse denial and say, we're not negligent, thanks very much. By the way, it was your own fault. Failed to take care for your own safety, full stop. That's still happening, but you're going to start getting pushback on it, particularly being raised on it in respect of on behalf of plaintiffs. And I think there's one case there, which is Nocton and Cool Runnings in 2021, where the defendant's pleadings were very heavily criticised by the Court of Appeal. That was a case involving a minor who was ice skating. And there was a whole host of issues in relation to engineering evidence and late engineering evidence. But one of the pleadings was that there was contrib alleged against the plaintiff, who I think was 10 or 12 or something at the time, and then that she caused the accident herself. And neither of those were pursued at the hearing, which again happens all the time. But the Court of Appeal, they weren't withdrawn, and the Court of Appeal, came down quite heavily on the defendant in that regard for not pursuing those pleadings, leaving those pleadings as they were, and not withdrawing them. And I think, which will bring me on to my next point in a minute, but I think the Court of Appeal are kind of waiting to have that sort of a decision again. I think they are starting to scrutinise defendants' pleadings a lot more than perhaps traditionally they had. Obviously, our pleadings are always a bit less than plaintiff summons, particulars, etc. But those days are starting to change, I think. So, I mean, defences are going to have to be very clear, specific and definitive, as per the rules on Morgan. If there's contributory negligence alleged, it can't be boilerplate either. It needs to be very, very specific. What are you saying they did wrong, and where and how? Obviously, an affidavit of verification has to be sworn. And then fraud is going to have to be pleaded. So there's been debate about this, obviously, back and forth. But I mean, there's fraud that comes up during the hearing that you mightn't necessarily know about, and there's fraud, like as in this was a set-up accident, etc. That has to be pleaded. And if it isn't pleaded, then you're not going to be allowed to run the defence. And again, bearing in mind the affidavit of verification requirement. So, the other argument that's kind of coming to the fore in all jurisdictions is in a defence denying that the plaintiff suffered the alleged or any injury. There are arguments that that's tantamount to sort of a fraud case, i.e. you're making up the injury. Therefore, if you're denying that there was any injury suffered in the first place, then you're saying that it's a fraud. I don't necessarily think that follows, but I'm just cautioning it because, depending on the rest of your defence, there could be some suggestion that there's a fraud defence, which mightn't be the defence that you are actually making if it just goes a bit over the top. You can certainly plead that they didn't suffer the alleged injury. If it is the case that you're saying that they didn't suffer any injury, then obviously you'd have to plead that. But as we all know, and I'm sure I'm guilty of it myself, throwing in denying that the plaintiff suffered the alleged or any injury, people are starting to pick up on that now and make the point where you're pleading fraud, etc. That can have consequences then in terms of, applications for costs. None of that has happened, but that's the way that things are possibly going. In the Court of Appeal, I've been there a good few times recently, and I have to say, I think the scrutiny is turning onto both sides as well. I mean, we know there's been traditionally a reduction of MAD awards and all the rest of it far too high. And the Court of Appeal don't have any decisions where they have in fact increased an award. But Collins and Parham, which is the case that I was in, was one of the latest guideline cases. Two things. Number one was, and I wasn't in the High Court, I was only in the Court of Appeal, but there was no submissions made from either side in relation to the guidelines. And we all know that's key, that you have to, guide the court in respect of quantum, in respect to the guidelines. And also the trial judge wasn't a personal injuries trial judge, so I don't think he was familiar either, in fairness, with how to apply the guidelines, etc. No case law was handed into him. And the only way that he was directed to the guidelines was, I think the plaintiff's counsel had said the dominant injury is either the teeth or the back. And that was about it. And that's what they said at the hearing, that no party had guided the trial judge in relation to the guidelines. But the damages were substantially reduced and the plaintiff didn't beat the appeal Calder Bank. However, there was still no order as to costs. I'm sorry, the plaintiff didn't reach the High Court jurisdiction. There was no cost differential order made. In fairness, the award was up around 55,000, so they weren't far off. But there was a reduction for contrib in relation to the seatbelt, and there always was going to be. So it did seem obvious that the case probably was never going to reach the High Court jurisdiction, but they didn't agree with that. And they made no order as to costs on the appeal. So that's despite the fact that there was a substantial reduction and they didn't beat the Calder Bank, which seemed very harsh. And the basis was that there might have been no need for an appeal if the court had been properly guided in relation to the guidelines. And again, that seems very harsh on the defendant in circumstances where neither party guided the judge in relation to that, and they had said that in their initial judgment. So that was kind of scrutinising, we felt, a bit more heavily on the defendant. There is a wide discretion in relation to Section 169 of the Legal Services Regulation Act in relation to costs. As we know, there's been a couple of times that a certain High Court judge, if told at the outset of the case, and she is usually told at the outset of the case, if there's been a refusal to attend mediation, for example, that she will say, well, there will be cost implications for that. Hasn't been a decision on it yet, but a kind of a flat refusal to go to mediation, could be mentioned at the outset, has been certainly in my experience a couple of times, and the response is, oh, well, we'll deal with that when it comes to costs. So, again, Section 169 came up in the Collins and Parham case as well in relation to the submissions and all the rest of it. And again, in another case that I was in recently, which we were all very, very surprised at, there had been an issue in relation to the plaintiff. The plaintiff had quite severe injuries, but the plaintiff had signed a letter at the start on invitation from his employer that he wouldn't proceed with, that he wasn't taking a claim. Obviously, that didn't find much favour in the High Court and was a big issue on the Court of Appeal. And in fact, the Court of Appeal, who seemed to be kind of ready to deliver a decision, but they rose for a few minutes, came back, and then invited, and the plaintiff, hadn't cross-appealed. They came back and invited the plaintiff to amend their hand, basically, adjourn the case, invited the plaintiffs to amend their hand and put in a cross-appeal seeking aggravated damages. Highly surprising to everybody, never would have expected it from the Court of Appeal. And I think we all certainly felt that the Court of Appeal are kind of waiting. There's been a few comments to the Court of Appeal in relation to, cases, Section 26 cases, what's the alternative for defendants? We know that if you have a basis for a Section 26 application, that there can be no aggravated damages against you, because if you have a basis for it, you have to make the application. And that's that. If you have no basis for a Section 26 application, that's a different thing. But what about the commentary has been, well, what about the conduct of the defendant or the insured or, during the case? And the feeling that we have is that perhaps the Court of Appeal are waiting to deliver a judgment against a defendant, and obviously nobody wants to be in that shoes. So, that was incredibly surprising when they did that, when they went out and they came back and made that invitation and adjourned the case for a few weeks, and ultimately the case settled. But I think that the Court of Appeal are waiting to deliver that kind of a judgment, and the couple of things that are, pleadings, if there's an allegation of fraud, could be in relation to pre-litigation correspondence, any of that kind of stuff. I think they're waiting to come to a decision on that. So just to bear that in mind. I promised I wouldn't talk about the guidelines, but anyway, here I am talking about them. Just very briefly in relation to the draft amendments. So we know that the draft amendments have been published. There's been an increase of 16.7%, which was the HICP index rate at the time in October of 2024. Every plaintiff has been arguing since that they're entitled to the increased rate. certain circuit court judges are applying the increased rate across the board unless they are very significantly challenged on it. And the challenge obviously coming from the fact that Section 100 of the Judicial Council Act, amended by the, of course, Family Leave and Miscellaneous Provisions Act 2021, says that they're not retrospective. But recently in Kilkenny, Mr. Justice Nolan in the High Court applied the 16.7%, and his reasoning was that he's entitled to depart from the guidelines where he sees good reason. And the good reason is that the increase has been published, the increase is there, and he's entitled to rely on the increased rate. And there's no appeal coming from that decision as far as I'm aware. So, you know, that's up until then, there was kind of circuit court judges applying it here, there and everywhere. But now there's been, you know, one application from a High Court judge. And I think certainly plaintiffs will, you know, if your case is initiated outside of the period where the guidelines were meant to have been reviewed after 3 years, there's certainly an argument for a plaintiff to make that they, you know, if they've got their act together, if there hadn't been the Delaney and PIAB challenge and all the rest of it, that they would have been entitled to an increase sooner, and therefore they should be entitled to that. And that could be good reason under the guidelines for a judge to depart and apply the 16.7%. So it's just to bear in mind in relation to certainly cases going forward while the new guidelines aren't yet kind of formally enforced. They are there in the background. And then very briefly, and I promise I'm coming to an end, nervous shock post Germain v. Day. Germain v. Day is the decision of Miss Justice Egan. It was specifically a medical negligence action, and it kind of arose on the back of a case in the UK where the court found that there was no duty of care owed to family members of patients, and therefore the law of nervous shock, they're much more restrictive obviously in relation to their law of nervous shock, but the law of nervous shock couldn't extend to sort of family members of patients. It was only the only duty of care that arose patients themselves. The same point was basically run here in Ireland, despite the fact obviously that Kelly and Hennessy nervous shock principles are different to the UK principles in relation to nervous shock. There's a very, very long-winded decision from Miss Justice Egan, but it is very good and well worth a read. She's very specific to healthcare actions, but at the same time, the door is open, you know, in relation to the applicability of the principles to any personal injury case. The one takeaway that I certainly have from it is that there's much more of a discussion about this one shocking event. And, you know, in that case, it was I suppose, a perfect example for a defendant to run. It was a sort of a watching their loved one die over a long period of time. There was no sort of shocking event. There was no road traffic accident. There was no seeing somebody who, you know, was in a terrible state in the hospital straight after an accident. It was a long drawn out process. And for Kelly and Hennessy and the nervous shock principles to apply, it has to be one shocking event. So my takeaway thing on that is particulars or interrogatories or both are really important in nervous shock cases. A plaintiff in their personal injury summons won't necessarily nail their colours to the mast as to what the shocking event was. If, you know, it's something like, you know, a husband died in a crush injury at work or something like that, you'll get, generally there'll be a phone call first. And the phone call, as we know, mightn't necessarily satisfy the proximity test. It's a bit too remote. Then they might come to the hospital and see, you know, a horrific scene that can't necessarily be avoided, but they might. The question is, which one is the shocking event, which is first, etc. There's law on the various phone calls and all of that. And they won't, a plaintiff won't necessarily, as I said, nail the colours to the mast until they have to. So particulars on that are really important. Pleading in the defence is really important. Denying that there's a shocking event, denying there's a duty of care if that arises in the particular context of the case. Again, I've said for the summons is going to have to be more specific. Following on from Morgan and ESB and all of that, the defence has to be specific as well. Duty of care could be an issue, but definitely the shocking event issue needs to be kind of the one thing that you probe a bit further than perhaps maybe you used to in a nervous shock type scenario. Some cases are being withdrawn. If, you know, I think people are analysing a lot more whether they have a nervous shock action. And, you know, some of them that might have been stageable before might have settled for small money are now just being withdrawn. So there has been definitely, or just not issued in the first place. So there has definitely been a big change since Germain v. Day, even though it is specific to medical negligence. The change is kind of across the board. Just saying there, they've restated the Kelly and Hennessy, nervous shock principles. Medical negligence is one thing. It's very, there's a clear kind of roadmap there. But just repeating again, the principles that we all know in relation to the Kelly and Hennessy principles. But additionally, I suppose Ms. Justice Egan went into the Glencar test in relation to the duty of care. So it's not just the nervous shock principles, it's also whether there's a duty of care, reasonably foreseeable, public policy, all the rest of it. That might apply depending on what the circumstances of the case are. But again, if your case is that there's no duty of care, again, you'll have to specifically plead it. Coming back to my previous point. But yeah, I think nervous shock, we'll probably see another decision. There's been a few decisions obviously recently. Morgan and ESB, there's a Dublin bus one, and then now this one, I'd say that's not going to be the last. And they are kind of narrowing. We're getting maybe slightly closer to the UK, but certainly they are more defendable than they certainly were beforehand. And I think that comes to the end of all of my waffling on just in time. But does anybody have any questions in relation to any of that? Which I know is a lot of information to throw at you in 45 minutes, but anyway.
I had a quick crossover question regarding limitation.
Yeah.
You were mentioning that if shock or sort of anxiety upset is being pleaded, then the argument is it should be treated as an injury claim with PIAB, and that needs to go to PIAB. Isn't one of the principles from the sort of Supreme Court that it has to be a recognised psychological condition? So if the anxiety that's been suffered is below the threshold of a recognised condition, it couldn't be an injury claim on the basis that there's no compensation for a mere anxiety, if there's no physical injuries to sort of base it off of.
Yeah, that's the thing that doesn't make sense about it. But there's Murray and Budds from the Supreme Court, which was a professional negligence case against a solicitor. And again, that had anxiety, stress, etc. And the court found that, in fact, that did meet the definition of a personal injury, but it wasn't a compensatable personal injury, but it still met the definition of a personal injury and therefore had to be authorised and should have been brought within 2 years. So this is where the discussion arises in relation to the GDPR claims, loss of consortium, etc. I mean, almost every case, to my mind, defamation, GDPR, etc. Of course, you're going to say the plaintiff suffered distress because, that's part of your cause of action. I don't necessarily think it follows that makes it a personal injury claim, but we've a case law there that says it does, and a very wide definition under the Civil Liability Act of any impairment of your mental or physical condition, including stress, anxiety, etc. So yeah, it doesn't make sense, but that is what the sort of undertone of the law is at the minute. So it'll be very interesting to see what the Supreme Court say. I'd be surprised if they said it met the definition of a personal injury case, because I believe there was a lot of discussion in the Supreme Court about the fact that it's not a Kelly and Hennessy scenario, and the only recoverable damages for recognised psychiatric injury, which, as you say, isn't that. But we'll have to see what the Supreme Court says, because the law is confusing, to say the least, on that point.
So applying to PIAB for authorisation to proceed for a claim that's not recognised
that you can't recover damages for. Yeah. Your damages are elsewhere. They're not for the stress, anxiety, worry, etc. But you still have to apply for an authorisation for it. That's where we are after Dylan.
Yeah. The other question I was going to put with, if you've agreed to PIAB assessing a claim and then the limitation period is up, with the sort of duty that's now incumbent on the defendant to sort of say, look, you're out of time, is it a matter of, if PIAB say we can't assess this anymore, it's time barred, does that sort of suffice from a duty point of view, or do you have to take action separately yourself?
Sorry, when you say that PIAB will say, just when you say PIAB will say it's time barred.
But can they assess a claim out of time?
Oh yes, and they will do. Yeah, no, they will do. So they won't tell you anything in relation to the statute. And I don't think the onus is on a defendant to say in advance, your statute is coming up or anything like that. But only in circumstances when you're engaging in, where there's been an open admission of liability and you're looking for a medical report and you're engaging in settlement as per sort of the Heslin checklist, for want of a better term. Then I think just to put something in, please note, we're not, you're still required to comply with the statute of limitations, or we still require you, or we're cutting off these negotiations by X date. I think that's all you have to say. And in my mind, it's actually too far, but that's what the law is currently. But yeah, I don't think there's any actual obligation on the defendant to warn the plaintiff when the statute's coming up. But no, the injuries board will take the claim no matter what. It's not a matter for them as to whether or not the statute is up.
Okay, all good. Thanks for clarifying.
No problem.
Thanks, Scott. Anybody else got any questions for Sheila?
No, everyone else has me on mute. Super.
You obviously did such a fantastic job in explaining everything that nobody has any questions of clarification. So well done. Thank you very much, Sheila. We really appreciate it.
Not at all. And you have my slides anyway, in case anybody wants them. Yeah,
and it has been recorded. So this will appear on the Foil website in the next couple of days or so, along with the slides. You can. We'll advise everybody where to find it, and they can go back and have another look if something occurs to them after the call's ended. So thank you very much for that. Please do keep your eye open for future Foil events. I know we've got one in the pipeline planned on e-scooters, which we're hoping to get through in before the end of March. Ian, are we?
It's looking like April now, so probably mid-April.
Okay, but please do keep an eye out for that. That's it. Just remains for me to thank everybody for turning up. I think this is one of the biggest turnouts we've had, so that's really good. And thank you again, Sheila, for your work. It's been really good, really fascinating. Thank you.
Thanks for having me. Thanks, guys.
Okay, thank you.
Bye,
bye, everybody.
Thanks, Sheila. Bye.
Bye.
Thanks, all.
Thanks, Sheila. Bye bye.